Hey, good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Tuesday, March 11th, 2025 at 1 in the afternoon. So we're here this afternoon to go through with a walkthrough and vote on H206, which is an act relating to the Universal Commercial Code. And with us is Smith, who is one of our UCC people that has been in this committee many times. And I think I was asking Carl, it's been probably about 6 years since the last time he was here. So Carl, welcome. Thank you for joining us again.
Thank you, Mr. Chair. It was that darn COVID that broke my record of streaks.
It was.
Committee. But I'm pleased to be back here with the committee. For the record, my name is Carl Listman. I'm a lawyer in practice in Vermont. My office was in Burlington until we lost our lease. So we shut down our firm. Each of us went in a different direction. I now practice out of my home in Charlotte, where it's 75 and sunny today. I am here as a uniform law commissioner. Probably most of you have no clue what that means. I didn't until I got appointed, actually. There are 6 uniform law commissioners in Vermont, all 5 appointed by the governor, and the legislative council is the 6th. Rich Cassidy from Burlington, who's the president-elect of the Vermont Bar Association. Ted Kramer from Brattleboro. Pete Langrock from Middlebury. Stephanie Wilbanks, who teaches at the Vermont Law School and lives in Stratford, I think. And Jennifer Carby, the legislative council, makes 6. We are all appointed by, other than Jennifer, the governor. So here is the first quiz of the day. There are no rewards other than self-esteem and the pride that you will feel for knowing the answer. Can you name all of the governors of the state of Vermont over the last 50 years?
I can name probably 4 or 5. I don't know if it goes.
Fire away.
It'd be Dick Snelling,
Yeah,
Madeline Kunin.
yeah.
Off.
Nope,
No, off.
more than 50 years ago.
That's more than 50?
Howard Dean,
Yep.
Jim Douglas,
Oh, you're doing well.
Phil Scott,
Yeah.
and
Shannon.
Sumlin.
And congratulations. You did very well. You have now named all of the governors who appointed me or reappointed me a commissioner.
Wow.
I've been coming to this committee for more than 40 years with uniform legislation. Makeup has changed, but the people in this room are always good, and I appreciate that. So you now know who the Vermont Uniform Law Commissioners are, but you don't probably know very much about the Uniform Law Commission itself. Let me take a minute or two. I'm not going to keep you here all day, by the way, just so you know, there is light at the end of the tunnel. The Uniform Law Commission is an organization of and for the states. There is a delegation from every state to the Uniform Law Commission, as well as the District of Columbia, Puerto Rico, and the U.S. Virgin Islands. Historically, the makeup of the Uniform Law Commissioner was 3 commissioners from each state. In almost every instance, they were appointed by the governor. Over time, the rules in different states changed, and the Speaker of the House got to appoint somebody, and the President pro tem, and the Chief Justice, and whoever. And the delegations got bigger. But we started, back when I started, there were 3 in the Vermont delegation. The Uniform Law Commission was created in 1892. We are the oldest organization of its kind in the country. It was created to establish a mechanism by which states could make laws uniform. You will remember from your history lessons that back in the 1890s or so, Congress didn't do much legislation in the area of commerce. That was ostensibly left to the states. The Interstate Commerce Act changed that a little bit, and then the laws started to change at the federal level. There are currently 400 or so uniform law commissioners. We come to our legislatures every year with products that we have created. We create them for a variety of different reasons, usually because somebody or some group comes to us and says, you know, there ought to be a law on this. We study whether there ought to be a law on that with a study committee, aptly named. And if the executive committee determines that a subject matter is something that ought to be a uniform law and will get a fair number of enactments, we appoint a drafting committee of commissioners appointed by the president of the ULC. The drafting committee, in turn, has a paid reporter who actually does the writing. We invite folks who have a dog in the fight on the subject matter of the proposed act to sit at the table with us at our meetings and to participate with an equal voice. People who are pro, people who are con, people who have knowledge, people who have a dog in the fight, people who don't want the law. And we sit at a table and we try to work it all out by consensus. It usually takes us 2 years to write a law, which is a long time, as you folks know, for that to happen. But we think that by and large, 2 years is the right amount of time to gestate and deliver. And when we're done, we think that the product that we've written is well written, easily, with some exceptions, understood, and appropriate for the states to adopt. I'm now going to bore you, if I haven't already started, with a list of uniform laws in Vermont that we've enacted over the years. This is not an exhaustive list, but it's intended to show you how broad the subject matter is that we deal with and how useful these topics are to the people of the state of Vermont. And it's in alphabetical order because my little mind can't organize it otherwise. Adoption, adult guardianship and protective proceedings, anatomical gifts, child custody jurisdiction, collateral consequences of conviction, the commercial code, which we're talking about more, the Common Interest Ownership Act, condo law, declaratory judgments, determination of death, disclaimers of property interests, an estate planning issue, electronic transactions. It's the law that allows you to do business on the internet. Estate tax apportionment, fiduciary access to digital assets, which you folks passed only in the last few years. When you die, who gets your Facebook account? Who gets your other accounts? And what rights do they have to them? Limited cooperative associations, limited liability companies, limited partnerships, management of institutional funds, mediation, notarial acts, parentage, partnership, powers of attorney, principal and income, probate code, prudent investor, securities, trade secrets, transfers to minors. If you have a bank account or a securities that either bought or somebody gave for your child and they put it in your name under the Uniform Transfers to Minors Act, because a person underage can't own that kind of stuff, that's that law. The trust code, unclaimed property, voidable transactions. There is nothing pretty much that we don't cover in uniform legislation. Some are very short. The Determination of Death Act is one section. The commercial code is 2 green books from your shelf, which is why I'm here. The ULC started working on a commercial code in the early 1940s and finished the initial project in 1951. For the record, I was not around then, notwithstanding what my children think. They initially finished in 1951 with the emphasis on the word initially, because it's still a work in progress. As technologies change, as commerce changes, as court decisions come down, there are needs to revise, amend, and update. I have to digress here for a moment to talk about the American Law Institute. The ALI is an organization of lawyers, judges, and law professors whose goal is, as is the Uniform Law Commission's, improvement in the law. It's an invitation-only organization. There are currently maybe a dozen or so Vermonters who are members of the ALI. I got my 25-year pin a few years ago. In the early 1950s, after the ULC had been writing, it came time to start going to the legislatures to get it enacted, which we haven't really described what it is, but we will in a second. Because there were really only 3 commissioners from every state, and there weren't even 50 states back then, they worried that they didn't have the manpower to get the work done in the legislatures. So they went to the ALI, have more members. And together, the ALI and the ULC have supervised the Uniform Commercial Code ever since. We have a joint committee, ALI members, ULC members, that watch developments in the law, write white papers when necessary, and are very protective of the commercial code. One of the remarkable things about the commercial code is that up until 1922, every state had exactly verbatim the same commercial law, all because they adopted the Uniform Commercial Code. It started to change in 2022 when some states started to enact the 2022 amendments, which is what are before you now. So we're a little out of kilter. We'll talk about that a little more. So what is the commercial code? It is what it's named. It is the commercial law of the state of Vermont and every other state, the District of Columbia, Puerto Rico, and the U.S. Virgin Islands. It is currently in 9 articles. I'll name them for you, although I suspect almost all of you took home your copy of the code last night and read it cover to cover. It's light reading. It's pretty simple to understand. And sadly, they took the pictures out. It was good with pictures, but without pictures is not quite the same thing. Article 1 is general provisions. It's what you might think of general provisions, including definitions, and there are lots of definitions. Our Uniform Laws Protocol is that in something like a code act, terms that are used in more than one article are defined at the beginning in Article 1. If a term is only defined in a particular article, it's defined only in that article. Article 2 is sale of goods. Article 2 covers the sale of everything that you and I will ever deal with other than real estate and stuff that you can't touch. We'll come back to that. Article 3 is commercial paper. For those of us who suffered through a law school course on the commercial code, this was the least exciting of all of the articles. It is dry. It deals with, as is the rest of the code, deals with negotiable instruments, notes, drafts, checks, teller's checks, traveler's checks, and so forth. Some of you may remember negotiable instruments of withdrawal. Now accounts, because credit unions, I think it was credit unions 30 years ago, weren't authorized to issue checks. So they issued negotiable instruments of withdrawal. Arose by any other name, has the same practical effect. There is a difference between a note and a check and a negotiable instrument of withdrawal, but they are very esoteric distinctions. For you and for me, they're all the same. Article 4 is bank deposits and collections. I write a check to the chair. I write it on my bank, the Bank of Montpelier. He goes and deposits in the Bank of Newport. There's a process by which that check goes from place to place to place. There are issues with endorsements and negotiation, and this law, coupled with federal law, is the basis by which that part of the economy functions. Article 5 deals with letters of credit, typically issued by a financial institution that is essentially the equivalent of money. That if typically say that if X doesn't happen, then you may take this letter of credit to any teller at our institution, and we will give you cash. Article 6, bulk sales, which we repealed, as did almost every other state, 20 years ago. Article 7, another fascinating, scintillating topic, warehouse receipts, bills of lading, and other documents of title. You don't care about this unless you hire somebody to move your stuff from point A to point B, or you put it in a storage unit. Then you do care about this, because this is the law that governs how your stuff is protected or not in that storage unit. Article 9 is secured transactions. Think of mortgages on personal property. And I'll talk a little bit more about that. We deleted Article 6, bulk sales, because we dealt with it by other law, primarily with our tax and labor law. It has to do when people sell their business or substantially all of their assets outside of the ordinary course of business to make sure that the government doesn't get cheated on tax payments, that employees don't get cheated on contributions and so forth. And not last but least, creditors don't get cheated by the person who's selling and absconding away with the sales proceeds. We've added 2 articles before 2022. Article 2A, leases of personal property, which parallels Article 2, sales of personal property. It turns out, geez, what a surprise that instead of buying something, you can lease it and have the same practical economic benefits and in most cases the same legal benefits. In Article 4A, dealing with funds transfers. This is primarily electronic fund transfers, wire transfers. I used to know how much money passes by electronic transfer in the United States every day, and I've lost the number. But what sticks in my mind is $27 trillion every day. This law, coupled with federal law, is what is the backbone that supports all of that commercial activity. So we come to the 2022 amendments, which is why you're here today. I don't know how many of you had to scalp your ticket to get your seat in this room today for this presentation, but whatever you paid, it was too much. Three reasons got us to why we have these amendments that are before you. The most obvious is the growth of the electronic world of commerce generally, and the emergence of digital assets, which we call intangible money. Secondly, the increasing use of what we call hybrid transactions. That's a term that we define now in the 2022 amendments, which I'll talk about in a second, which combines in one transaction the sale or the lease of goods and the provision of services. And the third is changes in defined terms and dealing with court decisions that might not have actually hit the right answer in interpreting the code. So in 2019, I was then president of the Uniform Law Commission, and I appointed a committee of Uniform Law Commissioners. The president of the ALI appointed a number of ALI members to a joint committee to look at amendments that should be made to the commercial code, dealing especially with emerging technologies. That committee met dozens of times. They too had observers, as many as 350 at a time in a committee meeting. The fellow who chaired this whole project is a Uniform Law Commissioner from Massachusetts, and he did a masterful job. We had observers from the digital world, from the electronic world. We had them from Europe. We had them from Asia. We had law professors. We had tech companies. We had big law firms sending delegations, presenting white papers. Anybody who had any interest in the subject matter of the committee was invited to participate and did participate. And what came out of it is the bill that you have before you now. There are 3 broad areas that I'm going to talk about in a way in inverse order to catch you up to speed and to refer you to different provisions in the bill that you have. The charge to the committee officially was to address how to accommodate new technologies such as artificial intelligence, distributed ledger technology, i.e. blockchain, and virtual currency. The committee focused on digital assets, which in this bill we call controllable electronic records, electronic money, and hybrid transactions and sales and leases, and some others that are beyond esoteric, and we don't need to spend any time. I downloaded today from the ULC website the map. Nobody can see this more than 6 inches away, but this is a map of the United States. It shows that 25 states have already adopted the 2022 amendments. And there are 13 states, Vermont is one of them, that is currently looking at the amendments in legislative form. It's in a bill form somewhere in those different legislatures. We're kind of hoping that by the end of this legislative session, 25 and 13 gets us close to 53. We know there will be some outliers, there always are. Texas marches to its own drummer, always has. But California has already enacted it. Florida is looking at it. New York is looking at it. So we're a little bit behind the 8 ball in getting this going. There's a member of this committee who will remember, Herb, that not the last time, maybe it was the last time that we brought the code here. We were the first state to enact the amendments, so we were more up to date than any other state in the union, for which we got no reward, but we all felt better about it. So let me start with hybrid transactions. This is something that we all can understand because we deal with them all the time, almost on a daily basis. Suppose that you hire a roofer to put new shingles on your roof. That's a hybrid transaction. The roofer is going to provide a service. He's going to take the shingles off your roof now, and he's going to put shingles on your roof, and he's going to sell you shingles. Well, when you and I think about that, we say that's one transaction. Why should I think about it as a hybrid? What's a hybrid? It's a sale of goods and it's the provision of services. And if something goes wrong, the question is, what law should a judge apply to decide the dispute between you and the roofer? If it's goods and the sale of goods, the judge will apply the commercial code. If it's something to do with services, you did a lousy job. You didn't put the shingles in every spot. You double laid them, whatever. Well, that's going to fall into the common law of contracts. Courts have struggled over the years, because this issue's been going on for a long time, as to which law to apply, one or the other or both. And the answer that the 22 drafting committee came up with, whichever part of the transaction is predominant should govern, unless there's a real good reason to apply other law. If the predominant factor is the sale of goods, then the commercial code will apply. If the predominant factor is the provision of services, then contract law will apply. Here's an example. Suppose, you have to really imagine, suppose I am a medical doctor. Suppose that I am the only medical doctor you can find, but nonetheless you come to me because you're not well. And I poke and I prod and I do tests and we get all done and I say to you, this is what you ought to do. Do you have a thermometer? No, you don't have a thermometer, so I sell you a thermometer. We've just done a hybrid transaction. I've provided a service to you and I've sold you a good. Well, is there any doubt in anybody's mind that what really predominates there is the service? So the law of contracts, general common law of contracts, will apply to that transaction. Here's another example. Suppose I own a warehouse and it's full of goods. And I go to you and I say, I'll sell it to you. And you say, I'll buy it. And then there's a dispute afterwards. Warehouse is real estate. The goods are personal property. Which law is going to apply? Well, the judge is going to have to figure that out. And probably what the judge is going to say, I can separate this. I can apply real property law to the issues involving the sale of and the purchase of the warehouse, and I can apply the commercial code to the sale of goods. So this is not novel, but it is important because people have spent millions of dollars litigating and having to fight over this issue as a preliminary issue. So that's a step forward, not very hard to understand. And that is probably the only part of what I'm going to talk to you about today that isn't hard to understand. Next, I want to talk to you about definitions and terms. So in the last go-round of amendments to the commercial code, we started to realize that electronic transactions were here to stay, but that we had a law in 2 green books that talked about writings. And electronic documents are not writings. So we came up with a new word, record, used as a noun, to substitute generally across the commercial code for writing, so that a transaction or a borrowing or whatever could be done electronically. It didn't have to be on a piece of paper, and it didn't have to have a wet, what we call an ink signature. That's worked out very well. There were some places in the code where the word writing wasn't changed the last time around because it didn't quite fit at the time. But you'll see if you flip through the bill, the strikeout in a number of places. Now writing has been struck and record has been substituted, even in those areas. But here's a word that we all thought we knew what it meant. And all of a sudden it has a different meaning, and that's the word money. Aha, show and tell. This is a 1974 Liberty silver dollar. You've probably all seen them. I don't need to pass that around. But this is something you probably haven't seen. A $3 bill issued by the Farmers and Mechanics Bank of Burlington. Sure, there's a date on here. It's got to be 17 something. That was, at the time, money. People exchanged money using these types of bills. Some of you will remember from your history the Bank of the United States and the fight over whether there should be a national currency and so forth. What else? This is money. It's 50,000 Russian rubles that I took home for me when I went to Russia as part of a bar association exchange, thinking that it wouldn't be a bad thing to have 50,000 Russian rubles, which today is not even worth the paper it's written on. I have no idea how much it was worth when I got it. But this one I do know. This is an Italian lira. You may remember that when the European community created the Eurozone, they created the euro, an exchange of money. And if you were fast enough, you could exchange your lira or marks or francs or whatever it was into euros. I did not. This was worth 625 euros to the dollar. This is a 1,000 euro lira note. You're going back? Would you give this to Bob? With my blessing. So there's money and then there isn't money. And now there's something called virtual money and fiat money. And it all matters because we're now all dealing in the world of commerce electronically. So with paper money, you could exchange it for goods or services. Here's $5. Give me $5 worth of services. Here's $5. Give me $5 worth of materials. You could buy it or sell it. You could sell your dollars for euros or whatever else. Or you could sell your euros for dollars. You could borrow against it. You could go to your bank and say, I need $10,000. Your banker's going to say, I would love to give you $10,000, but let me ask a few questions first. Do you have a job? Do you have a source of income? Do you have an ability to repay? Yes, 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 yes. Have you got any collateral that you can put up to secure this $10,000 loan? Well, I have a bank account here in this bank. Aha, that's what they used to call a passbook savings loan. You would pledge your savings account to the bank as collateral for the $10,000 that they gave you. If you didn't repay, they just took it out of your account. How do you do those things with electronic money? Here are 7 Bitcoins. Pass them around.
You're rich.
You're very rich with 7 Bitcoins. You can't pass them around. They're intangible. They don't exist physically in any form. So the bulk of the changes to the commercial code that's before you had to deal with stuff like that. How do you negotiate? How do you transfer? How does your buyer know that when you're transferring 7 Bitcoins, that she's actually getting 7 Bitcoins? And maybe as important or more important, that somebody doesn't have a mortgage on those 7 Bitcoins or a better claim to those 7 Bitcoins than you did, so that when you actually get them, you actually own them in real property terms. When you say fee simple absolute, you own all the bundle of rights that go to those Bitcoins. And that's what Article 12 of the commercial code that's before you addresses in a lot of words, some of which I don't understand. A digression. I described to you earlier Articles 1 through 9 of the commercial code. And I am bringing to you now Article 12 of the commercial code. That might cause you to ask, what happened to 10 and 11? I didn't mention those before. 10 and 11 were transition provisions after amendments were done, and they disappeared because the transition was completed. So you can't abolish them. You can't pretend that they're not there because they're technically there, even though they're not there. So they went to Article 12, and that's what we're going to talk about now. I'm going to talk about now for not a whole lot longer. Notice that I am carefully putting away my 50,000 rubles, which is worthless. But my $3 coin, bill, may actually have some value.
You might be surprised that's probably worth more than you think.
No, I think it probably is, yeah. I started a coin collection when I was in 6th grade, and I still have it. And I added to it maybe through high school, and I put it in a briefcase. I dug it out of the briefcase last night. I can't lift the briefcase, it's so heavy. I think I have a valuable coin collection, but I don't know what to do with it because I don't know who to trust to go through it. My problem, not yours. That's not why I'm here. I'm jumped ahead of myself. I'm sorry. There's one other definitional change that I want to call to your attention, and that's the word conspicuous. When the commercial code was written, there were provisions in it that dealt with notices and disclosure of information that people should have when they're doing business transactions. When it was written, everything went in a writing on a piece of paper. I suppose it could be papyrus, but mostly it was paper. And how do you make something conspicuous when you're dealing with paper? You deal with font, size, and type. So much of the code would say 16-point bold type for this legend or that notice. But now that we're dealing with electronic business transactions, font size and type size, and it doesn't work. But what does work is that you can make things conspicuous by pop-ups or by text balloons or by having the text grow and blow up at you or shrink down, or even have the machine that you're working on vibrate. So we have deleted in these amendments the definition of conspicuous by reference to type size font and have gone to a better standard, which is the totality of the circumstances. Is it conspicuous based on the totality of the circumstances? I must say that you know, of course, that the world is divided into two groups of people. There are those of us, that's me, who look at a smartphone or think about NFTs or digital currency and marvel at the advances of technology and science. And then there are the rest of you who grew up with all of this, for whom it is normal, everyday stuff, and you deal with it in the ordinary course, and it's not particularly special to you. You don't look at a smartphone and say, I remember, old IBM machines that were bigger than this room that only could punch out punch cards. And now my cell phone is more powerful than whatever we take to put people on the moon. Enough of that. There are other definitions: chattel paper, a controllable account, electric money, electronic money, tangible money. They're all scattered. I can cite you to them. I'm going to talk about them in a moment. If you parsed, as I know you did last night, with the little notes that you put on the copy of the bill that you read last night, you'll find that substantially all of the changes are new Article 12 and changes to Article 9. Article 9 is secured transactions, mortgages on personal property. Mostly everything else are conforming amendments and definitional upgrades. So I want to go back before I go forward to talk about secured transactions so that you have a better understanding here. If I offer to sell you Blackacre, lawyers, law professors talk about Blackacre, Whiteacre, an imaginary parcel of land. Any size, improved, unimproved, doesn't matter. It's just an imaginary parcel of land. Blackacre. I'm going to sell you Blackacre. And you want to buy it. So I say to you, $50,000. In exchange for that $50,000 check that you give me, I give you a deed. You immediately run to the town clerk's office and you record the deed in the land records. Very important in Vermont that you do that. In the deed, standard deed in Vermont is a warranty deed. I say in the pre-printed form, I own this, I own Blackacre, and I have the right to sell it without having to go to anybody else to get their permission. And it's free and clear of any claims of any other third party, including easements or rights of way or judgment liens, unless I specifically list them in the deed. And the fourth promise I make to you is that I will defend this title if somebody makes a claim against you based on my deed, the 4 warranties of a warranty deed. And you record it in the land records because that gives notice to the whole world that you now own the real estate. And because you got a warranty deed, you own it free and clear of any claim of anybody else, unless it was listed in the actual deed itself. And that's how it works with real estate. Real estate is unique in the sense that it's not movable. You can't pick it up and move it. You can't take Blackacre and move it from Chittenden County to Addison County. You just can't do it. You dig up the dirt, it's still Blackacre. Whatever's left, it's still Blackacre. And that's a major differentiation between real estate and personal property. So here's another example. I walk into a jewelry store and I want to buy a diamond ring. And the salesperson says to me, I'll give you a deal, sell you this ring for $5,000. I say, great. Do I stop to do a title search? Do I have a lawyer go check whatever records there might be to know that the jeweler actually owns this ring, that it isn't there on consignment, or that he didn't steal it from somebody else, or that he's got a mortgage on it from the local bank that's financing his inventory? No. I give him my $5,000, he gives me the ring. Because personal property is movable, there is no central place to put anything in writing to say, I own it, I have the right to sell it, so forth. Suppose I don't have $5,000. Suppose I have $500. And I say to the jeweler, I'll give you 500 down. I'll pay you $4,500 over time with interest. Or the jeweler looks at me and says, Listman, there's no way I'm going to do that for you. Go to your bank. So I go around the corner to the bank. I sing the same song to the banker. Of course, we'll loan you $4,500. We'd be pleased to. Either way, I'm going to end up with a ring, and somebody is going to be owed $4,500. Whether it's the jeweler or the bank, under the commercial code makes a bit of a difference. The jeweler can say to me, here's a piece of paper I want you to sign for $4,500. It's called a promissory note, governed by the commercial code. Promise you pay me back $4,500 on these terms with interest and so on. I sign it. The jeweler gives me the ring. Same thing would happen with the bank. I walk out the front door. I see you. I say, hey, you want to buy a diamond ring? I'll sell it to you for $6,000. You say, great. And you peel out $100 bills from your pocket, which I know you have. I put them in my pocket. I walk away. You've got the ring. Either the jeweler is out $4,500 or the bank is out $4,500. There ought to be a way to prevent that from happening. Aha, there is. The jeweler or the bank can take a mortgage on the ring. We call it a security interest under Article 9 of the Commercial Code. What happens is the borrower and the lender sign a document which we call a security agreement. It's just an agreement that says, I'm loaning to you and you're borrowing from me on those terms, evidenced by a promissory note. And now there's a way to give notice to the whole world that the bank or the jeweler has a mortgage on that ring until the borrowing is paid off. And that's by the filing of a financing statement with the Secretary of State. It's a form, it's in this book. It's called a UCC-1 form. You may have heard people talk about that. It's done electronically. It's easy to do. There's a small filing fee. And the Secretary of State maintains a database. And that database, if I want to go and look up, since I bought it from you, your name, to see whether anybody's got a claim against any personal property that you own. I may find that there's a financing statement listing your lawnmower or dining room sofa, a dining room table, living room sofa. But if I don't see that there's a ring there, then I'm allowed to believe that you had the right to sell it or to buy it from you. I lost my story. My point is that Article 9 of the Commercial Code provides a mechanism to perfect what we call a security interest mortgage on personal property. And that's worked really well for a long time. I'll digress, tell you a story about this committee some years ago. It used to be in Vermont that you had to file a financing statement, not only with the Secretary of State, but also with the town clerk of the town where the borrower lived. I think back then it was $5 to file with each, so it was a $10 fee. When we came with amendments some years ago, you may remember this better than I heard. The code was changed to eliminate local filing and just do it at state level. And there was gnashing of teeth in this committee about taking away the $5 fees that the town clerks got for these financing statements. When it got to the Senate, it went to the Senate Finance Committee, and I can't remember who it was who said, it's crazy to continue dual filing in Vermont when they're doing away with it in every other state in the union. The solution is let's double the fee with the Secretary of State and require the Secretary of State to remit half of it back to the towns. Same result, same financial result, a little less paper for the towns. Somebody else on the finance committee looked to whoever that was and said, not precisely these words, but pretty close. That's the dumbest damn thing I've ever heard in my life. They got rid of the dual filing. They did not double the fee, and we moved on. Sausage making. It's very interesting. We've now talked about a way to perfect a security interest in goods by filing with the Secretary of State. There are two other ways to perfect a security interest, to make valid a security interest in goods and personal property. One of them is taking possession of the good that is serving as the collateral. As the passbook savings account example is a good one. Another one is for the jeweler to say to you, I'll give you a bill of sale today. You give me the $500. I'll just hold on to the ring until you've paid off the rest. And when you've paid it off, I'll give you the ring. The jeweler took possession of the collateral. That's the second way to perfect a security interest in personal property. The third way is by something called control, which is slightly different than what we're going to talk about in Article 12, but it's close enough that we can smush them together. This concept arose back in the 80s. Sorry, they all sort of run together. When there was a real crisis in backroom processing of stock certificates at the stock exchanges. People were buying and selling securities in increasing amounts. There were more and more issuers who were listing their securities on the stock exchanges. And the process was, I own 5 shares of, I'm not going to say Tesla, I'm not going to say General Motors, I'm not going to say Amazon. I could say Unilever, I could say Ben & Jerry's. I own 5 shares of Ben & Jerry's, and I sell them through a stockbroker to somebody. I don't really care who the somebody is as long as I get paid, right? I give my stockbroker the stock certificate for the 5 shares of Unilever. The stockbroker sends those through the stock exchange process. The stock exchange then sends them to the registrar, the agent for Unilever, to change on the records of Unilever's listing of shareholders that I am no longer an owner of 5 shares. You are now an owner of those 5 shares. And then the transfer agent would issue a new certificate to you. Not a very simple process to begin with. And when you're doing millions of transactions every week, they just got overwhelmed. So we amended Article 8 of the Commercial Code, and the feds amended their rules on the stock exchanges to deal with what I love to call the most wonderful oxymoron of all, uncertificated certificates.
Wow.
It's the law in Vermont now. It's the law in every state now. And instead of issuing pieces of paper, we said to these companies, you can issue uncertificated certificates, book entries. You can just keep a record. And then we don't have to push paper around. And that works fine, worked very well. But the people who borrow against their stock ownership, they would have had an opportunity to be potentially less than honest, because the lender who's loaning against those uncertificated certificates doesn't want them sold or given away. They want them as collateral if the loan isn't repaid. So the concept of control of, for lack of a better word, not the UCC definition, of intangibles, stuff that you can't touch. How do you control something that you can't touch? And we came up with the idea of a control agreement, so that with the stock certificate, the uncertificated stock certificate, again, you and I can sign an agreement. I own 5 shares. Sorry, I took them back. 5 shares of Unilever. You lent me $5 and you want collateral for that. I can't give you the certificate because it doesn't exist. But we can sign an agreement. And with that agreement, you can go to the issuer and say, Carl owes me $5 and he gave me the uncertificated certificates as collateral. Will you change your records to reflect that I have security interest on those certificates and don't let anybody else take them without me releasing my security interest? And it works. And that's sort of the underpinning for Article 12 as well with digital currency. Geez, by now, usually the whole room is empty. So there are 3 ways to perfect a security interest in personal property: filing, possession, and control. Because there are 3 different ways to perfect a security interest, and because more than one person may have a security interest in the same collateral, there have to be rules as to which of the 3 forms is the most protective. And the answer is control trumps filing, and possession generally trumps everything. Possession is 9/10 of the law. We've all heard that expression. I have no idea where it came from. I've never been able to figure it out, but this is the best example of that when it comes to mortgage interests in personal property. Article 12, I wrote down the page. Article 12 deals with controllable electronic records. Not all electronic records fall within the definition of controllable electronic records. And they are a subset of digital records. So now, in fact, I'm actually going to steer you to the bill and cite you to section 12102A1. I thought I had the page number, but I don't. 12102A1, it's page 107, I think. A controllable electronic record is a record stored in an electronic medium that can be subjected to control under section 12105. The rest of the stuff is exceptions that we don't have to really spend any time on. What this really says is that a controllable electronic record is a record that is information that's retrievable in perceivable form. It's a controllable electronic record if it is stored in an electronic medium and can be subjected to control under 12105. So not all digital stuff is governed by Article 12. It has to satisfy those 2 standards. But those 2 standards will include virtual non-government money, non-fungible tokens, NFTs, and digital assets in which specified payment rights are embedded. I know I'm starting to get into a foreign language here, and I apologize. NFTs. NFTs are unique digital certificates of ownership for a digital or physical asset. They use blockchain technology. Do we know blockchain? We don't, you know both. They can be used to represent a variety of items, art, music, real estate, event tickets, and a lot of other stuff. They are increasingly popular. Article 12 applies to records, controllable electronic record. Article 12 applies to records, not to rights evidenced by the record, except, and it's the exception here that's important, it applies to rights to payment evidenced by a controllable electronic record, and as to which the obligor, the borrower, undertakes to pay the person who has control of the electronic record. The principal function of Article 12 is to specify certain rights of a buyer and a secured party of a controllable electronic record. And by doing this, Article 12 essentially makes these controllable electronic records very similar to a negotiable instrument. Think back to the 1930s. None of us can think back to but we can think about thinking back to the 1930s. If I go to New York City and check into a hotel, and the person behind the desk says, well, it's the 1930s, $14 a night. How will you be paying? Well, I'm going to be there a week. There's no way I'm going to have that kind of cash in my pocket. I'm going to pay by check. Oh, on what bank is your check drawn? Well, the Chittenden Bank of Burlington, Vermont. Well, sir, I'm not sure that we can do that, because how do we know that that bank exists? How do we know that you have money in your account to cover the check? How do we know that you're not a forger? And on and on and on. Beginning in the 1600s, people had to deal with those kinds of issues. If you don't have cash or gold in the 1600s, how can you transact business? So merchants figured out a way with their banks to create a system that allowed people to be comfortable that a check or a promissory note issued by somebody is a valid debt obligation, collectible either through the bank or the issuer of the debt. That's really important in the electronic world as well. How do you know? Well, there have to be rules. And what the rules do is they say, if you do A, B, and C, and D, then you're protected. And that's essentially Article 12. With electronic currency, NFTs, and other digital assets. I need to go back, though, and make clear to you that the amendments that you have before you, which define money, do not change federal law on what is currency in the United States. What we do in the Vermont, what you do in the Vermont legislature cannot change federal law. Some countries now say that they have made Bitcoin their national currency. If Bitcoin becomes the national currency of another country, then it is fiat money. It's government issued money, even though you can't touch it. Generally speaking, we don't deal in the commercial code with fiat money. Bills issued by the United States Treasury, coins issued by the United States Treasury. We don't, that's not our bailiwick. Article 12 deals with intangibles, those non-fiat monies like Bitcoin and a lot of the other digital currencies that are out there.
Just to clarify, so at the point that Bitcoin becomes fiat money, some other entity is dealing with that?
Yes,
Okay.
yes. If Bitcoin becomes a national currency of the United States, Congress will deal with that.
Oh, not just the United States, but if we're dealing with like another country that has declared, was it like Colombia or something?
Yes, it could have been Colombia. Might not have.
Declared Bitcoin their national currency.
That's outside this.
This is outside that, and some other agency would
Right,
deal with it.
right.
Okay.
So if you go to invest in that currency from that country, this law will not deal with it. So I want to go back to the real estate deed and try to cut this short. What Article 12 does for intangible money is essentially to set up a framework that says that if you do A, B, C, and D, your purchaser, the people you are doing business with, your lender, can be comfortable that you are the owner You have the right to sell it. It's free from a claim of anybody else. And that once you have departed with it, you no longer have any rights to it. So I love this. When I wrote this down, when you spend a Bitcoin, it's really not an accurate statement. You have the power to include in an unspent transaction output in a message that the Bitcoin protocol will record to its blockchain that you have transferred it. English much we often speak. I don't understand this at all. I get it. I don't understand the underpinnings. But what Article 12 does is it says, if you have the right to transfer, if that power is exclusive to you, if you have the right to transfer that power to somebody else, and you can demonstrate that you have transferred it to someone else, then the law will protect that someone else from the claims of your creditors. And you can then do with it whatever you want, whatever you got in consideration for it. So I wrote this down to, because I don't want to mislead you. If you have an electronic wallet that contains Bitcoin, you control it if, one, you benefit from the use of it as a medium of exchange by spending it or exchanging it into another currency. Two, you have the exclusive power to prevent others from doing so. And three, you have the exclusive power to transfer control of the Bitcoin to another person. That's almost everything. One more qualification, one more thought, and then a conclusion. Not all, all records have value. Bitcoin has value. You can buy it, you can exchange it, you can use it as an investment. Some records evidence rights in a transaction or rights to other property other than the Bitcoin itself, which means that Article 12 differentiates between the record and the rights evidenced by the record. Right now, we're dealing with paper records and electronic records. Who's to say that there won't be a third form of record that pops onto the scene tomorrow or next week or next year? And this law has to be ready to deal with that. And that's part of what this does. The rules for all of that are in Article 12 and in Article 9, the mortgages of personal property, conforming amendments to deal with stuff that you, with this bag of Bitcoins. One thing that I did not share when I asked the chair to bring this bill to the committee is that current version of the commercial code and all the ones that precede it have, in addition to the black letter law, the official comments to every section. And I would ask that the committee modify, I'm not sure what the right word is, the bill to make sure that the official comments to the 2022 amendments are included in the bill when it's approved by the governor. Notice I said when, not if. When it's approved by the governor. So I think I said, started coming to this committee and others more than 40 years ago. More than 40 years ago when I had red hair and was a little engaged in local politics, I made a decision. I stopped my involvement in politics completely. Because when I come to this committee or another committee, I want to come as a true, independent, impartial person whose only goal is to bring to you a law that I think the state of Vermont ought to have. I have no clients who care about, a lot of clients who care about this. I don't care about that. I'm not being paid by anybody. I've never been paid by the state of Vermont to be a uniform law commissioner. At my lawyer billing rate, I conservatively could say I've given away hundreds of thousands of dollars of time to the Uniform Law Commission, maybe even millions. I sat last weekend with a Uniform Law Commissioner from Pennsylvania who said, only by a slip of the tongue, that she charges her clients $1,700 an hour, which is only a few pennies more than I charge my clients in Vermont. No. You've got 400 Uniform Law Commissioners across the country who are giving away their time to improve the law. This is the point at which I could say, trust me, this is a good bill, you should pass it. I should never say that to you. But I can say to you, this bill has been written and studied and vetted by lots of people who are smarter than I am, who fully understand it and who say it works and every state ought to have it. And I conclude by saying, I'm here to answer whatever questions you have and to thank you for your time and for your commitment to the people of the state of Vermont. It ain't easy being a legislator. Even I know that. And the payback that you get, I know the millions of dollars that the state pays you for being a legislator is partial compensation. But the real compensation is doing the right thing. So thank you for doing that. Questions?
Thank you, Carl. Any questions? Or
Yeah, Herb. Excuse me. Representative Olson.
I would say one of the things that's really has changed since I last dealt with this subject matter. I'm really impressed with our legislative council these days. Really am. I had a reasonable good knowledge of this back in the 90s, but not to the degree I think that legislative council has now. I'm really impressed. But I'm also impressed with Carl's testimony. The one, I was doing a little reading over the weekend, and the one area that I was not fully, I didn't fully understand, holder in due course, and whether the holder, you should probably explain that term, because you could do it better than I. You know, to what extent holder in due course is treated differently under under the electronic records versus, you know, some, you know, the more, you know, traditional kind of transaction. You know, you can correct me if I'm wrong. My impression was that somehow the original holder had less rights, but, you know, you can explain that.
This is a
3302.
3302, thank you. This is a,
And
you want to explain it?
And the reason why I was asking it just because the committee's had a lot of testimony around, you know, fraudulent transactions and the impact that that can have. And, you know, the whole due course, well, you explain, you know.
Do you have a
a little bit
page
better.
Sorry, page number?
it's I don't think it's in the bill.
Oh, it's not in the bill.
It's, there are provisions that are analogous in the bill. So the holder in due course doctrine sort of relates back to the example of checking into the hotel and how do I know your check is good? Generally speaking, it's a concept that again says that if you do A, B, C, and D, then this is the legal result. But instead of doing, it's the document itself. And there are 3 or 4 conditions that the document must satisfy in order to allow the person who holds the document to be a holder in due course. And why does it matter if you're a holder in due course? Aha, because if you are a holder in due course, you take that note, that promissory note, free from the claims of anybody else. Even if the guy that you got it from had a claim against it that was valid, you take free of it. So what do you have to be, what does the document have to be in order for you to be a holder in due course? When issued or negotiated, transferred, It doesn't appear to be a forgery or to have been altered or is not otherwise irregular or incomplete or call into question its authenticity. It's up. It's a piece of paper. Here is a promissory note. Please note that it's not signed for $2,250,000 that the chair generously agreed to lend to me. You can slide that around if you want to, you don't have to. It's issued, it's done today, and it's due tomorrow. And he graciously charged me only 18% interest, which I think is $11,000 a day on $2.25 million. Be that as it may. Does that appear to be a forgery or an alteration? Is it irregular or incomplete so as to call into question its authenticity? It looks like what it ought to look like. And if it had a signature on it, which it will not, you might be able to tell whether it had been altered. So that's one condition. Second condition is that the person who holds that piece of paper who's trying to either borrow against it or sell it paid value for it, did so in good faith, and without notice that the note was in default or otherwise irregular, including whether the signatures were authorized or unauthorized. And without notice that somebody had a claim against it. So if the chair, if I were to sign that note, and if the chair were to endorse that note over to Representative Olson, and then Representative Olson wanted to borrow against it or to sell it to somebody else, he would say, I'm a holder in due course because I paid value for it. It doesn't appear to be irregular in any respect. I bought it in good faith. I'm unaware of anybody's claims against it. And therefore, I have cut off the claims of anybody else on that document. So when he presents that to me and says, pay me, your note is delinquent, I can say, oh no, he held a gun to my head and forced me to sign it. And that's not my signature, it was forged. And he can say, I don't care, I don't care, doesn't matter, I'm a holder in due course. The same concepts apply to these intangible monies, these digital currencies. They don't fully enact the holder in due course doctrine, but the result is the same. And that's in Article 12.
Can I send a pen down with you?
No, I'm sorry, I've broken all my fingers and I can't sign with my thumb.
I have a follow-up. So are there any, we've heard a lot testimony about fraud in terms of these kinds of transactions. And I'm wondering if your committee, the study committee heard about that, whether they thought it was important enough to, well, obviously they thought it wasn't important enough because they're basically following the holder in due course concept over to electronic record. And I'm just,
Let me
and I
try.
guess I'm fine with that. I'm just wondering whether there are any differences in terms of this kind of transaction, in terms of people being able to know whether it's, maybe not. I mean, you wouldn't know whether someone has a gun to your head, I suppose. You maybe have a little better opportunity to understand whether it's forged.
When I sold my 5 shares of Unilever, I had no idea who the buyer was. And I didn't care who the buyer was. All I wanted was payment. And I trusted the process that we talked about earlier to ensure that I would get paid and that the buyer would get the certificates or the uncertificated certificates. With blockchain technology, the veracity of the Bitcoin is ostensibly authenticated through the blockchain. If I have the key that allows me to transfer 5 Bitcoins, then the same concept as holder in due course applies through the blockchain technology. That's about as good an answer as I can give you because you're getting a little bit above my pay grade. But I think that's, and just to finish, this project, the amendments to the commercial code, don't deal with that issue of fraud in the digital currency world. I sat in on a committee meeting yesterday, the first ULC study committee on deed fraud, something that I do understand a lot about. And the problems with deed fraud are different than the problems with digital currency fraud. It appears that most of the deed frauds all relate back to electronic notarization. Not all, substantially electronic notarization. Topic for another time. But ostensibly, anyway, the problems of fraud are outside the scope of the commercial code because it's formation of contract, I think, and it's not the sale of goods.
Thank you.
So, thank you. I appreciate your presentation. I think I need you to go back to the very beginning, and I'm going to reiterate what I remember you saying, and then you're going to help me kind of finish that. So in 2022, a group of specialists from across the United States put together this update to the language. 16 states have already included it?
25.
25 states have already.
25 have, and I think 13 are in the current session of a legislature elsewhere.
And the goal is to have
53.
everyone do it. That's it. I just wanted to, because that, I don't want to lose that.
No, that's important, I think.
Thank you.
Say 53. Yeah. You did.
That includes the territories.
It includes the District of Columbia, Puerto Rico, and the Virgin Islands.
Okay.
It might include Guam. Guam talks about wanting to be a state within the meaning of the Uniform Law Commission, but they show up and then they disappear and then they show up.
I guess how long does it generally take to update the language across this is unique to happen.
We're a little slow on this round.
Okay.
It's not moving as fast as the last round that we did, which amended every article of the code and substantively as well as just conforming. That went very quickly, and we had a date deadline. I can't remember what the date, but it was a January 1 of some year, and we met it. Every state did it.
How long ago was that?
Yeah, Representative Olson, how long ago was that?
When the complete revision was?
Yeah.
19
It was, I think, I don't know the exact date, but it was right after, we had a major recession in the 90s.
January 1, 1995.
Yeah, there we go. So it was reaction to a whole bunch of economic development pieces that were put together and enacted, and this was one of them because it's kind of foundational. in terms of-
Sorry.
Nonsense, huh? It was kind of a foundational economic development.
Well, now, here's an example of an alteration. If it were stitched back together, somebody would say, no, wait a minute. And that's all you have to do to lose your holder in due course status.
If it was photocopied with that
Yes,
jagged black
yes,
line
you
across
bet.
it, that might be a movie.
Question, Ricardo?
Just out of curiosity, you said that Texas runs by its own, but are there any other states that are resistant to the changes, or are they it's just so?
There have been a few states in the Upper West that were sidetracked by some folks who didn't understand that the commercial code can't change federal law on money. And that slowed them down a little bit. But otherwise, I'm not aware of any opposition from any of the bankers or the insurance companies or the stockbrokers or anybody who deals industry generally with the subject matter of this.
Do you have Attorney General representation or input, into that study?
I can't, yes, yes. I can't remember remember there were 350 people.
Yeah.
But there were, the Attorney General's NAG was there.
This would have no bearing on state element, like insurance that, so this is, I'm just realizing that that's something that I guess, are there other areas that this of other industries that this doesn't touch?
I think it touches everybody and everything. If you're doing electronic transactions. We have in Vermont the Uniform Electronic Transactions Act. Congress passed e-sign after we adopted UETA, the Electronic Transactions Act. It's the law that allows you to do business electronically. Since every state has UETA, except I think one which then relies on e-sign for the same consequence. Everybody's doing business electronically. And the next step is to do electronic compensation payment electronically, which is digital currency. I don't personally do it yet. I may never do it yet, but the rest of the world is doing it increasingly so. So this change to the commercial code will affect everybody, every business in the United States.
A lot quicker than I thought it was gonna
Me
be.
too. Thank you for staying awake. It's not, as I said, the most scintillating topic that you will ever deal with, but it's really, really important.
I think maybe a question for Rick is your suggestion, Carl, of including the notes.
Commissioner Collins.
Do we have to add anything to draft?
So I need to talk to so Rick Sagal, Office of Legislative Counsel, I need to talk to probably Tucker and then maybe even Brent about if that's possible. We would need to add it to the bill.
Right.
If you want to include it, but I'm not even sure. I think we're going to Green Book. I'd have to see what we can do to do that.
But we've done that in the past.
Yes, you did that with the UCC, you did it with the Common Interest Ownership Act.
Yeah.
And I think maybe voidable transactions, I can't remember.
I just need to check out if we can. There may have been a reason why we didn't do it last time. I wasn't here.
You did do it.
In 2015?
I think so.
Okay, well then, I just need to see how to put it in. Okay. Are those comments in that draft, that version you sent me?
No,
Not along. The electronic format here.
it's, I'll send it to you.
Okay.
Okay, so. How long will that take?
Well, I need to run over to Aiken. See, talk to drafting operations and see how to format that correctly. And then he needs to give me
I'm not proposing that the bill include comments. I'm proposing that the bill include a requirement that the comments be printed in the Green Book.
Okay. Yeah, so the comments don't have to be in the bill,
Correct.
just the language that says that they be put into the green.
Okay.
Can you check that out and
Yeah. Yes.
and I would like to move this afternoon, if it's possible. And I think instead of making it a strikeout, we just make it an amendment to,
Yeah.
it's very small, minor.
Good. I have one more UCC story that I could tell you.
Yes, that'd be great. I think it's,
So the last time I came to this committee with the amendments, I was here for a number of hours and we went through it line by line and word by word. And it went to the Senate, to the Finance Committee. And when I announced why I was there, almost everybody got up and walked out. First time that happened, I was a little offended, but after a while, I realized that's just the nature of the beast. When I finished, whenever that was, the chair of the committee said that they would vote immediately, and they did. And then the chair looked around the room to see who would report the bill on the Senate floor.
oh, that's why everybody left.
And then Senator Shumlin was sitting up to my left, and the chair congratulated him on his appointment as the reporter of the bill. Senator Shumlin came up to me afterward and said, "Can you put together a little cheat sheet for me, maybe one sentence on every section, so that when I get to the floor, if somebody asks me about it, I'll have a ready answer." I spent an entire weekend writing one-line explanations on the day that the bill was up for a final reading. I think it was set for 10 o'clock in the morning. And I walked into the Senate chamber at 9:45, and there was nobody there. So I walked into the office. Might have been Dave Gibson was still there then. And I asked Dave, "What's going on? My bill is up and I want to find out, I want to be here." And he smiled and he said, "Well, they started at 9 and they quickly ran through their agenda. So they approved your bill at 9:15 without any discussion at all." If you're not prepared, that's when you get called on.
That's right.
Everybody knows that. That's my sad story. Thank you again. I really appreciate your attentiveness and your willingness to take this up.
Carol, thank you. Many years.
And I am available if you need me for anything.
Thank you.
Write up a one line for.
No.
Hey, so Rick, if you could check that out and then let us know what.
I have several days.
Now, didn't we have? Yes, so we have one more person,
Jim Knapp.
Jim Matt.
Let's go call for a second here.
Afternoon, Jim.
Hello, thank you for inviting me.
Thank you for joining us.
For the record, my name is James Knapp, generally go by Jim, and I'm here as the co-chair of the property law section for the Vermont Bar Association. I can be a lot briefer than Carl because I don't have to explain all of this, fortunately. I do have to say that having read through the bill, Carl did a brilliant job of explaining the UCC and how important this legislation is. I want to reemphasize the fact that you all know that the commercial world is very complex. My background, I practiced law here in the state of Vermont for 42 years, 25 years in private practice, 10 years with various title insurance companies, a couple of years with the Bar Association. And there was that unfortunate couple of months of unemployment, but we won't go into that. And I spent all of my career dealing with property law issues. And that, of course, means dealing with the Uniform Commercial Code in many areas. And I was thinking back to a transaction that I was involved in, and I'm going to not use any names to totally protect the innocent and change a few states so that nobody can tie this together. But I was working with a Vermont business that contracted to have some product manufactured in Massachusetts, which was going to be sold to my Vermont business. But because the Vermont business didn't have space to deal with it, they had made arrangements with a warehouse in Rhode Island to hold on to the product and drop ship it as needed. The deal was actually financed by a bank that had offices in Connecticut and New Hampshire. Can you imagine the mishmash of the laws that we would have had to try to figure out if there had not been the Uniform Commercial Code, so that all of us, and believe me, everyone in all of those businesses that I talked to was represented by at least one, if not several lawyers. If we hadn't had the Uniform Commercial Code to create a uniform platform for us all to understand everybody's rights and responsibilities, the deal never would have happened, because contract law in the various states it can be wildly different. So that's probably the ultimate reason why I think that adopting these amendments is an excellent idea. The Bar Association is behind this. We support it 100%. And these proposed amendments are really a key element of the process, because we're switching to so much of our business transactions going away from paper and physical records to digital records. I am recently, well, a couple of years, happily retired, so I'm not directly involved in this anymore, but I'm very much connected to the Bar Association. I do a lot of continuing education programs for the Bar Association, so I try to keep up with the law as it's happening. I talk to a lot of folks who are still in practice about stuff that they're doing. And so I understand how important it is to have the uniform rules to apply, and I really want to encourage that this is a good set of amendments to adopt. The second point I wanted to make was Vermont was at one point a very early adopter relating to various kinds of digital transactions and digital platforms. We have our blockchain type entities that were approved in maybe 2017, 2018. There are a whole group of various projects that were looked at as potential digital projects in Vermont. Digital land records haven't gotten off the ground yet, but there's always still hope. You'll hear from me at some point. And so having the Article 12 amendments that really encapsulate and most importantly create in the NFTs, all of those kinds of things that Vermont was an early adopter on. It's important to keep up with the law and to continue to make progress as the law develops and as the law changes. So as I said, the Bar Association property law section, we're behind this and we encourage you to pass it. And I'm happy to try and answer questions, but I certainly will defer to Carl on anything that relates directly to the text of the bill.
Thank you, Jim. Any questions for Jim? I think we share your hope for getting our land records electronically. We during COVID, it was a very difficult experience, and I'm sure you were part of that. You had that experience. So we're hoping that we're going to be able to continue to push forward on that piece of it as well.
That would be great. I know that the Secretary of State just adopted the final rules to allow for digital notaries and the procedures for digital notaries. So that element has fallen into place. And so the next step really is, can we figure out how to make a platform work for digital land records? And I will tell you that over the last 4 years, I've developed some ideas when people are ready to hear them.
Very good. Well, thank you very much for joining us this afternoon. We appreciate your input.
All right, thank you for having me.
Thank you. So I think we will break. And we'll come back as soon as we hear from Rick and he has that small amendment done. And we'll hopefully pass